Hello, this is P.R. Krishnan. Welcome once again to my presentation episode number 2 on inheritance law. In the last video, we looked at introduction, a basic understanding about inheritance law and why we should go in for it. In this video, we will see what is will, the various terms or definitions, and the need for will. Okay. Now let's look at and understand what is a will. Put it in simple words, it is putting it in writing your wish to distribute your wealth. To whom do you wish to distribute? To whoever you have chosen to be the beneficiaries and who are supposed to be benefited by your wealth. It could be your spouse, children, parents, or even relatives and even outsiders. And this is your last wish. Languages, you can make it in any language you want, be it English, Hindi, Tamil, Bengali, Malayalam, Marathi, Gujarati, Assamese, Bhojpuri, whatever language. Now let's look at your wealth and ancestral wealth. This is important to know because what is your wealth? Your wealth is one which you have acquired by way of buying a house or a furniture or jewelry purchase, etc. This is your wealth. Ancestral wealth is your father or forefather's wealth that is still not distributed. Once your forefather or father wealth is distributed and you get a share in it, it becomes your wealth. The reason I am stating this is in will you can distribute only your wealth, not your father's or ancestral wealth. So while making a will, if your father's wealth is still undistributed, it becomes ancestral. But once it is distributed, then it becomes your wealth. Suppose you have made a will and some years later your forefathers or father's wealth is distributed and you get some share out of it. Since you have already made a will, what do? You can add these newly acquired assets in a separate sheet and attach it to your existing will. Attachment is called codicil. Like in the exams hall, you are given a original one answer sheet. The moment you complete the answer sheet, you call for extra sheet, additional sheet, and that you attach it behind your original answer script, right? So both are clubbed together and kept. Similarly, here also you can add this newly acquired sheets separately and attach it to your will, original will. This attachment is called codicil. Ancestral wealth, if there is no will left behind, then it is divided equally between spouse and surviving children of the ancestor. If there is a will, of course, it will go as per the will. In your case, now that you are still there, you can make a will and you can distribute your wealth as per your wish. Maybe it is unequally to your spouse, children, parents, or you can even add outsiders like maid, CA, or driver, etc. You remember the famous case Priyambada Birla, who bequeathed her entire assets, Birla, 5,000 crores or more to her CA RS Lodha. And all this RK Birla, BK Birla, MK Birla, they all this Birla group people they fought. And it was in 2004, if I'm not mistaken, but in 2021, the Supreme Court get the verdict that Lodha is the owner. Matter finished. In ancestral property that is not distributed, all the direct lineage will get equally, irrespective of male or female, if there is no will. If there is a will, as I told you, it will go as per the will. And once it is distributed, it loses its ancestral tag. Let us understand what wealth means or includes. Wealth includes your bank account, bank deposit, shares, loans, your furniture fixtures, your costly paintings, um, your investments, your gold, etc. And even immovable assets like house property, land, business, even like cars, vehicles, etc. Will comes into play only and only after the death of the testator. So nothing to worry till you are alive. You will be the owner, but only after your death only the will come into play. There are various acts involved, personal laws for Muslims, Hindus, etc. We shall be dealing with it in great detail in some subsequent video. I now move to the next chart. Terms. This is a very important slide. Please pay attention here. Testator. What does testator mean? Testator means a person who is making a will. He is a creator of the will, the owner of the property who wants to distribute as per his wish. Codicil. What is codicil? It is like an addendum or annexure or additional page which I just explained a little while ago, which will form part of the original will. You can call it an amendment to. As per Act, codicil means an instrument made in relation to a will and explaining, altering or adding to the dispositions and shall be deemed to form part of the will. Intestate. When a person dies without leaving a will, he is said to have died intestate. That is, it is a state where the person dies without leaving a will. Beneficiary, also called legatee, is the one who benefits, as you all know. It means those persons who will get a share as given in the will by the testator. Executor. Executor is very important. An executor is the person appointed by the testator to represent him after his death for distributing his wealth. Very important to choose him or her correctly. He, she could be any relative, spouse, children, or even outsider. He is your representative after your death. On your death, he takes over and represents you and distributes your wealth as per your desire. He has to execute as provided under the will. Probate. This is again important. It is a legal procedure required for executing a will. This needs to be done through court proceedings. The court conducts its hearing and authorizes the stated executor to implement the will as given by the testator. They put the stamp and seal of the court, making it legal. This enables the executor to review the will, administer the will. At times, it is also referred to as copy of the will, certified under the seal of the court. The definition is probate means a copy of a will certified under the seal of a court of a competent jurisdiction with a grant of administration to the estate of the testator. Custodian. All of you know what a custodian means. When there is a minor, his interest needs to be protected. So if you are making a will, you will appoint a guardian or a custodian for the minor to take care of his interest till he becomes a major. Similarly, there are people who are incapacitated or of unsound mind. Therefore, in order to protect their interest, you or the court will appoint a custodian to take care of his interests till he or she is able to manage or becomes capable of managing his or her share. The custodian is like a trustee. Lastly, I mentioned about class of years. There are three classes. Of course, I'll talk about two classes here only. Class 1 here includes spouse, children, mother, etc. but does not include father. It also includes if any son dies, then his son and so on. Father is included in class 2 here along with sister, brother, son's son, daughter's son. Class 3 is there. We will discuss class 3 covers all other relatives, but we will discuss in detail in a video later on. Okay. Now I will take you through a visual presentation of all the terms that we have discussed, and I've made a small story out of it so that it implants in your mind who is a beneficiary or who is a trustee or who is an executor or what is probate, etc. Right? So let's go to the straight away go to the chart. Come to the left, this gentleman, Mr. Singh. He is owner, he is the father, he is the person who is now going to create a will. So he is called the testator. Right? Testator is the person who makes the will or creates the will or makes a will. Okay. Now he has his wife, Mrs. Meena Singh. His first son Akash is here, and second is his daughter Avantika, and third again second son is Ambar. These four people I am calling them beneficiary because his estates and his wealth, these four people will inherit. Beneficiary 1, beneficiary 2, beneficiary 3, beneficiary 4. These four people will benefit from his estate. Now, one thing I have not written here, which I will also tell right away. This beneficiary 1, beneficiary 2, beneficiary 3, beneficiary 4. There are also legal heirs. This we'll see sometime later when we talk about legal heirs. Okay. Now, Mr. Akash, Mr. Singh is the owner of textile business. He's got a house also. He's got 2 factories, and he recently passed away. And he's survived by his wife Meena, uh, sons Akash and Amber, and daughter Avantika. While now I will just slightly I'm varying this. I'm saying if he has made a will, what will be the situation like? So I'm putting a position here of where he has made a will, and I'm also saying here when there is no will, when he has not made any will, what will be the situation? And there's a small fight between the 2 brothers. Very simply put, when there's a will, there's no dispute because he has written it, and it is his wish, so nobody can dispute that. So, but what he does, he has to make an executor. He has to appoint an executor, which he has created with Mr. Mehta. Mr. Mehta, maybe we can call him, is a relative of his of Mr. Singh, or a cousin of Mr. Singh, and who is about 10 to 15 years younger. Why 15 years younger? Because Mehta has to survive Mr. Singh. If he dies, then of course this will have to be again, you have to choose another executor. So Mr. Mehta knows about the will, so he appointed Mr. Mehta, and then when Mr. Singh dies, Mr. Mehta takes it to the court. Here he takes it to the court, and he does the probating. Once probating is done, he then takes charge, reviews, then administers the will by distributing whatever these 4 beneficiaries or whoever he has named will get it. Okay. Now let us look at the second condition, when there is no will. When there is no will, obviously the elder son will think, or I took care of my parents all along. I have spent so much money. So he feels that he should get some 60% or so, whereas the younger son thinks he should get 50% of his business and wealth, as he has been running the business profitably. Of course, daughter doesn't say anything, mother is just a spectator. Now, when there is a difference, it leads to a dispute here. What happens? You can't go for probating. The matter goes to the court. You all call in lawyers, spend a lot of money. Again, when it goes to the court, there's a huge time lag, maybe 2 years, 3 years, 4 years, or 5 years, depending on the complexity of the dispute. After the dispute is resolved, then on the 5th, 6th year, 3rd year, whichever year, then the court sends it for probating. So there's a time lag, the money involved, the appointment of lawyers, the cost involved, and misunderstanding between the siblings, right? So this I have tried to present in a small chart, and this is the quote I have put it here. I have just said quote here, quote, and this is the probate part. Now let's go to the next chart, the need for will. We saw in the chart above, if you don't have a will, it could lead to dispute. Outsiders can lay a claim, leading to court cases and long delays. There's very often the case we have seen outsiders laying claim because there is no will and they try to take something out of it. Secondly, it is basically to avoid what you had planned. Let's say you had planned to give 50% to your wife, and your 2 sons Akash and Amber and 1 daughter Avantika 17% each out of the 100%. 50% and other 3 get 17% each. If you don't make a will, then it goes as per Hindu Succession Act and all 4 gets 25% each. So 2 sons and daughter get 25% instead of 17% and your wife gets less, that is 25% instead of 50%. But if there is a will, it will go as per the will. And if there is a will, the Indian Succession Act will apply. Guardianship. As we have already seen custodian and other things, like in case of a minor, his interest needs to be protected, and this ensures custody under guardianship in case of minor till he becomes major. Okay. Now, again, by giving it in writing, the mistrust that comes among the siblings later on is removed. This we have seen in the example also. To avoid any confusion at a later date, in respect of the share of the testator's wealth, it is best to give it in writing and make a will. You can reduce any legality or complication later on, as all are in black and white. When you are applying for a probate, you get it very fast. Probate is very fast if you have a will written. Now again, to the siblings and spouse and all, everybody's share is fixed. Okay. Friends, in this video, I have introduced you to will, prepared a base for you to understand the subject, because in the next few videos, we get into the core of the subject and you will need this basic understanding. In the next series, I'll start on the topics like what happens if a will is not made. If you make a will but not register it. If you make a will and register but not probate it. This is important. Keep watching this space. Do not forget to press the bell icon, subscribe, click on the subscribe button and leave a comment. Thank you so much.